Hi, everybody. Welcome to our edition of KML Foundation Table Talk Vlog. I'm really happy today because I bring back a previous guest, attorney Andy Falkowski. Today we're going to be talking about powers of attorney. I'm guessing you've heard of them, but today we're going to be specifically talking about what they are, but also who needs them. I'm excited to bring this episode to you today. So as we get ready to talk about powers of attorney, first of all, welcome, Andy.
Thanks, Paul. I appreciate you having me back.
You know, we're talking about powers of attorney, and I always like to start with just the very basic, simple explanation. What is a power of attorney?
Sure. I mean, in simplest terms, it's appointing someone you want and trust to handle your decisions in life if you are unable to handle them or you need help handling them. In simplest terms, there's a healthcare power of attorney, there's a financial power of attorney, and that's the definition.
So we're talking two different, you're talking health and finance. Is there any crossover between those two? Are they completely separate? How does that work?
The documents themselves are separate, or in my opinion, should be separate, but there's definitely crossover. Maybe the healthcare agent can make decisions on where you live and maybe choose the assisted living facility. But when it comes to the finance department, they're going to want the signature of the financial power of attorney on that document. So there is times there can be crossover between the two. That's why you don't have to name the same people, but you have to make sure those people are able to communicate, cooperate, somewhat work as a team, I would say.
Okay, so let's start first of all with the health, the power of attorney for healthcare. When does that kick in? If someone creates one, when does it actually take effect?
Sure. That one is quite easy to answer. That is defined under state law, and it is activated by a doctor. Now, the state of Wisconsin healthcare power of attorney form and most healthcare forms require the signature of two doctors stating you are incapacitated, not incompetent, incapacitated. I have had clients where you were incapacitated with a stroke. 3 months later, you regain your capacity and can take over those decisions again. So it may not be a final statement of incapacity. In some cases, it may be. But the law also says that if you work with an attorney who prepares your power of attorney, you can set your own standard. So in my firm, for instance, we use one doctor because we find chasing down two doctors can be challenging at times in this world we live in. And so we just trigger by one personal physician allowing the activation of the healthcare power of attorney.
Okay. So you name this person. I mean, can you name anybody? Are there any limits on who can serve as that healthcare agent?
That's also a good question. Obviously, over the age of 18 would be a requirement. Competence, willing to act. And then there is the one rule I know of where you cannot name your own personal medical provider. So even though you love your general practitioner and he or she would do a great job, they will deny. So a nurse or a doctor treating you could never do it. Now, if your son is a doctor out in Minnesota, he could do it because he's not your treating physician.
Can you name more than one person?
That you are hitting all the top questions here, Paul. So I would argue or say that is a kind of a gray area of law. The statute implies person. Doesn't say persons, it says person. But I will say there's a large majority of estate planners who say 1, 2, 3 only. There's also a large majority of estate planners that would say, no, we can do co, but I would if somebody said to me, I want to name my daughter Jane and my son Tom, I'm going to say I will do that, but I'm only going to write it if it says and or with independent power. Because if Tom is off on a business trip in New York and he can't be reached, the hospital is going to run to their legal department, and we're going to have some problems there. And so I would not ever tell a client or recommend doing joint. Now, Should Tom and Jane in my example communicate? Absolutely, they should communicate. And I would argue any of your children should communicate on major health decisions about your parent. But I'm real cautious on the two, but I will do it if a client really pushes that or wants that, but only with the and/or type of combination.
I think that's really wise, because you see too many cases where, again, you'd think children would get along and they'd all agree on everything. You know, I've got children. I can't remember the last time they all agreed all 100% on something. So it's, in spite of what you might want, that's probably not wise, and you might be putting your children in a bad situation. I think from my experience, a lot of times people pick their spouse. And then, well, if their spouse maybe predeceases, or maybe they're not able to serve, that maybe you then pick somebody else. So it's not a but maybe more of a, one after another. I don't know what you'd call it, but something, consecutive or, continuing. Would you recommend that?
Absolutely. My thought is, if you're taking the time and effort to execute a healthcare power of attorney, I would definitely name up to 2 agents. You can name 3, you can name 4, you can name 5. Now, to be clear though, you got to make sure that person is capable, willing, able, and that's a person you're comfortable talking about your medical decisions or your thoughts on medical decisions. So some people, the 7 kids, and they'll name them all, and I'll say, really? And they'll think about it and go, no, these 2 would really be the best in that role. So it's picking the role also. But yeah, I support naming of multiple agents in consecutive order. Absolutely.
I mean, if the doctor comes to me and asks me what I want, he or she will listen to my wishes. But what if I can't answer and I've chosen a healthcare agent? How do I know that my doctor is going to actually listen to my healthcare agent?
Yes, this is a concern expressed by some of my clients. And I guess the best I can say is, if you have a valid healthcare power of attorney, if it has been activated properly, that doctor and nurse and clinic and hospital are supposed to honor the decisions of your healthcare agent, with a caveat. They're not going to do anything that they find against general medical standards, medical ethics. I hate to get into these issues, but the classic is, if I get Alzheimer's, I want to die. Well, you could live many years with Alzheimer's disease, and that is not something you write in your healthcare power of attorney that a doctor is going to honor. And so we want them to be honored, but you have to also be within reason and within the Hippocratic oath and do no harm to patients and those types of things. So that's where we kind of cross into medical and law, kind of intercede sometimes there. But in general, I've had very few issues with children or agents making decisions for parents within reason having a problem with a doctor.
Oh, good. And I think you raise a good point. These medical directives are meant to name the person who's going to make the decisions, not that you're making all those decisions. So you talked about maybe I don't want to live with Alzheimer's, but I'm not putting that in my medical directive. I'm naming the person who's going to make the decisions for me. That's what the power of attorney is. When we start talking about these, so I've named this person who's going to make decisions for me. And so a life issue comes up and a decision has to be made. Does that person make the decision that they think I would want, or do they make the decision that they think they should make or would be right?
It's a very profound question. I would, the legal answer is the agent is to make the decision that you would want or that you had previously expressed to them or made clear to them. If there is a gap where the kid comes in and flies in and says, well, Mom never talked to me about this. I have no idea what Mom wanted. Then the answer is you are to act in the best interest of the patient. Again, life. And that is what the doctors and the Hippocratic Oath in the state of Wisconsin fall on that side. And so they're going to do anything within reason. Now, if you are terminally ill or persistent vegetative state, that's where, there are, some things can be viewed differently. But in general, your decision should not substitute the decision of the patient. You are to act in the best interest of that patient.
Good. So you've named somebody to be the healthcare agent. You talked about when it takes effect. When does it end?
My position would be it ends upon the passing of the client. And so upon that death, that job and that document become void. It is just void by law.
And I guess that makes sense, doesn't it, Andy? That if they're acting on your behalf, how do I act on my behalf if I'm not alive anymore?
Correct.
So I guess that makes sense. Now, we talked at the very beginning about two different kinds of powers of attorney. We've talked about the health. What specifically is the power of attorney for finance?
Sure. It is, from the estate planner's perspective, it is a comprehensive document that covers many, many issues. I laugh. When I started, I think our power of attorney for finance was 2 pages. I'm now up to 6 pages. I don't do that to charge more. I do that because every year lawyers learn more and say, ooh, the post office needs this. Ooh, what about digital assets? What about my Apple ID? How am I going to get my pictures? All these things. So every year we go to these seminars or through now learning, and we add more powers and provisions to the power of attorney, because there are cases out there, Paul, that say you can only do what the document says. So you can't just sign a form that says you're my power of attorney. You got to get into the nitty gritty. When you're dealing with large corporations and financial institutions, they're not going to take your word for it. They're going to want to see paragraph 1.74, says you can do these things. So I explain that to my clients when I mail it out, and I say, some of these things may never affect you, and I understand that. But I'd rather throw the kitchen sink in there than regret not throwing it in there after you're incapacitated or incompetent and you can't sign a new one.
Sure.
And so that's how we do it.
So with the healthcare power of attorney we described, you answered, when does that kick in? When does the finance power of attorney kick in?
That is client choice. The most of my clients, especially the spousal cases, use durable. If you ever see the words financial durable power of attorney, that means valid the day you signed it. Now, to the married couple, that shouldn't be a problem. I mean, you hope your husband isn't going to go to steal your checking account or whatever. But the theory is we don't want to chase a doctor down in the hallway and say, could you sign this form? I have to cash a check or pay a bill. And so we try to keep doctors out of most of them, the people who want durable. Now, I may have a single client who says, I don't have kids. I'm going to name my neighbor lady, but I don't want my neighbor lady to have that power and access now. Then we can use what's called springing. And so in the document, it says this document becomes activated upon the signature of 1 doctor or 2 doctors. So we can tie it to doctors, but most of my clients go durable. But in the unique cases or cautious cases, or maybe they have been scammed before or something like that, I'm a big fan of springing in those cases, because then I know that person can't do anything at the bank without having that doctor's signature there first.
Makes sense. So these are clearly important documents. Who should have them?
I would say, and I'm not pushing the young kids to run out to an estate planner tomorrow, but I would say anyone over the age of 18 is allowed to sign a healthcare power of attorney or a financial power of attorney, and I think they are the most important estate planning documents. When I talk to my clients, we talk about death planning and beneficiaries and all these things, but you cannot imagine the things and the stress that can happen with an accident, a stroke, head injuries and these things. And to have these documents keeps us out of what's called guardian court. Guardian court is a 3-ring circus I would not wish on my worst enemy. There will be multiple lawyers in the room. You may have to come to a hearing and have a judge take away your legal rights. I mean, it's the most sad situations ever. And so powers of attorney avoid that. We sign them, we put them in a drawer. We hope we never need them, but wow, are they helpful if you ever encounter one of those medical or health issues where they're needed, and you're really saving your family a lot of stress, time, money at some of the worst times in people's lives.
And that's true. That's so sad. And we talk at the beginning about how people usually want to avoid having to go to an attorney or having to go to court. Seeing an attorney and maybe drafting some of these documents is going to do exactly that. It's going to avoid some of those problems. And and I often like to tell parents of 18-year-olds, you graduate from high school, you're heading off to college. This is a document you should consider. I've heard too many cases where your daughter's maybe 4 or 5 hours from home. One night you get a phone call from the roommate saying, yeah, we were out skiing and your daughter yeah, she fell and she broke her leg and she's in the hospital here locally. I just thought you should know. And so first of all, logical, I'm going to call the hospital, right? I'm going to say, hey, is my daughter there? And how's she doing? And legally, they might not tell you anything, not even that she's there. Unfortunately, HIPAA rules really kind of dictate some of those communication options. And now what do you do? You might say, wait a minute, I'm paying the bills. She's my dependent. You don't have that legal right without the document. So I do believe this case, yes, I agree with you, Andy, 18 years old, certainly this document. That doesn't mean you're creating a will and a trust necessarily. No. You might, but you might not need that at this point, but certainly the power of attorney. I guess I'd have to ask then, is there anything else that you can think of here, Andy, that we should be informing our viewers?
I think we covered things pretty well. On your comment about the young kids, though, going off to college or the military, I absolutely agree with you. And if you're not comfortable calling an estate planning attorney, or you don't have an estate planning attorney, or there's no time before they get off in the car and leave, I will say the state of Wisconsin Department of Health Services, if you Google it and Google advanced directives, they have them. They're free. You can hit print. Now, as attorneys, do we think our documents are often better than the free states forms? Yes. But you know what? Like you said, for an accident or a mom cashing a check back home, that comes in the mail, stuff at a bank account or something like that, I think I'll take a state healthcare power of attorney form over no power of attorney form. And so as just customer service, I often offer that to clients all the time where they don't have the time or they don't have the money or they're not sure they want to work with a lawyer. Go ahead and look those up, and those will fill in a pinch well.
Well, and I respect you for saying that as an attorney, because I think most attorneys would say, don't go the Zoom, don't go the online, the internet route. But in this case, those documents are free. This is the one legal document that you don't need an attorney, but I think you're right. You certainly want to be talking about the attorney because you want to be talking about a comprehensive plan, not just one document here. Thank you again, Andy. I think this is really practical. I think this is important information. Thanks for sharing your expertise in this case.
I appreciate it. Thanks, Paul.
You bet. We often end these vlogs and podcasts with the saying that we do this because it's your life and it's your plan and it's your legacy. Well, in this case, this really is very practical. I don't think there's anybody that shouldn't consider having these powers of attorney, and especially for the health care. I think Attorney Falkowski made that pretty clear. If you want to learn more about that, certainly contact a local attorney. You can contact me with some basic information. I'm not an attorney. I'm not going to drop documents for you, but I can lead you in the right direction and provide some resources for you. Thanks again for tuning in. We look forward to seeing you next month.